My Lord, since we are still at the prosecution case, we had expected our colleagues to come up with a memorandum initiating the process which we present before you. Unfortunately, we are here to get but
Council, I will read section 7(3). The prosecution come up with the memorandum or its court?
My Lord, court comes up with a memorandum, but initiation of the process, that's what I was talking about. Court is the one who prepared the memorandum. Subsection 2, my Lord.
Yes.
At the conclusion of a preliminary hearing held under this section, the court shall prepare a memorandum of the matters agreed, and the memorandum shall be read over and explained to the accused in a language that he or she understands, signed by the accused and by his advocate, and by advocate for the prosecution and then filed. My Lord, the memorandum is largely about agreed facts, but the preliminary hearing is not restricted to agreed facts under subsection 167.
For court to prepare the memorandum,
No. For court to come up with agreed facts, there must be a preliminary hearing on the matters, issues, or rather with issues that will promote fair hearing, fair trial. Under subsection 1, by the subsection 1. Notwithstanding section 66, if an accused person who is legally represents pleads not guilty, the court shall, as soon as convenient, hold a preliminary hearing in open court in the presence of the accused and his advocate and of the advocate for the prosecution to consider such matters as will promote a fair and expeditious trial.
So I address to it, that's where we are now.
That's where we are, my Lord. To have the accused persons before you, the prosecution before you, and lawyers to come up with issues regarding fair trial.
Move to 2.
Subsection 2?
Yes.
That's what I was reading, my Lord, before coming to subsection 1. That at the conclusion of the preliminary hearing, held under this section, the court shall prepare a memorandum of the matters agreed. Because the first is okay, the matters agreed. And the memorandum shall be read over and explained to the accused in a language that he or she understands, signed by the accused and by his or advocate and by the advocate for the prosecution, and then finally.
Let's go to 1.
1, we have come up with a number of issues, my Lord, we consider to be pertinent at this stage.
What is great issues with the prosecution?
Now, my Lord, the thematic areas will be considered to be the preliminary trial.
So from the defense side?
From the defense side. Number 1, my Lord, facilities required by the accused person. That's issue number 1. The issue number 1, facilities needed or required by the accused person under Article 28.
What are the facilities?
My Lord, we shall come to those issues because now I'm just generating the issue.
Just tell me where the facilities.
My Lord, first of all, there are 2 categories. 1, those required at Lucia where they are incarcerated.
You mentioned under one.
Under one, they are twofold. They are those required at UC. And those ones are documented, my lord.
You have them?
Yes, they are documented, my lord. And a copy was given to court. But number one, my lord, so the case was filed on Friday, my lord. Yes, on the case.
Okay.
But we can proceed to
Yeah.
can supply a copy. Can supply a copy.
Yes.
As I read out, my lord.
Let me have the copy.
Number one, my lord.
Said you filed it on the case.
On the case, on Friday 5th.
This is the copy.
Yeah, my lord, that's the copy. Go to the document, Jessica, my lord.
The one in your letter.
Yes.
I have. I have.
But they are not on record here, my lord. That's why I was looking for them out.
It is in the letter that was filed on the case.
On the case on Friday. May I proceed to read out
Yes, wait, I want to capture the idea.
most of it?
Can you give a constitution also?
My lord,
This.
we filed it on the case. I am not
Do you have a copy?
not advised whether the lawyer
Give
serving.
them the one we were giving. From that copy. This is the letter. These conditions are in the letter dated June.
Yes, my lord. I can read through very fast now.
I have the copy.
But my lord, here is the copy.
I have captured
My lord,
the conditions and report as the letter.
I seek for the indulgence of court.
I have taken note of these facilities which you requested court as that are required.
My lord,
Council Clark,
I'm making a request, my
I
lord.
have them here.
Yes, my lord, but now,
Kindly proceed with this. I have these conditions. You find them on Friday. I have got them.
my lord, I was making reference to section 67. The spirit of section 67 of the
So
TIA.
I am saying these facilities are required there, Zira and some.
My lord, if I may be heard. If
I'm
I may
saying
be
these ones.
No, yes, my lord. Section
Kindly
67.
require. Proceed with other.
No, my lord,
This one is okay. You submitted it and I have got it.
But my lord, on this record, the gadget has not captured me. I need to be captured.
It has captured you that the facilities required, you communicated to court and they are.
Yes, well, that's the reason I was going to the spirit of section 67. That it has to be done in open court, in open court and in the presence of the
I have to
person.
read.
Yeah, they need to listen to
I
the
have to
facility.
read.
But my lord, it's very simple. You can read out the list.
I have the list, you have it, kindly proceed. This one, I have it.
My lord, the reason why section 67.
I have finished.
No, but my lord makes a provision that the accused persons must be in open court. They need to listen to this. They have no copy of the letter. Maybe you give us 5 minutes, we'll hear with the accused persons.
I am saying you find this rate.
Yes, my
This
lord.
condition.
Yes, my lord.
I have said, first finish what you are saying.
But they have not seen it, my lord. They requested that we see them before coming here, and you directed that we do everything from here. And that's the reason we are
I
here.
am saying.
Since we were brought, we have not
And I
interacted
want
with
to come
this.
back, but I think it is on your part. I have taken.
But my lord, I am asking now for fair trial that the accused persons should be brought on board.
Can you proceed? But
Yes, I'm ready to proceed, my lord, but they should be on board. This is the point I am making. They are not on board as to the facilities required, my lord. They should participate in the proceedings. That's the spirit of section 67. Yeah, but my lord, they need to understand it. Maybe you give us time so that we discuss it with them.
Any other issue? This one will come back.
But my lord, it's all about this. The reason actually we are here. The reason we are here today is to go through these issues, to flash out these issues. The preliminary trial. No, the preliminary trial is all about that, my lord. The preliminary trial is about this. The preliminary hearing is about thrashing out these issues.
I have said this is a republican. I am give me chance to get this one. Kind of. We shall come back and see.
My lord, how do I proceed now?
Any other issue apart from the other issues that.
So when shall I particularize the issues required, my lord?
Let us finish other issues.
No, there are other issues, my lord. But I wanted to first exhaust this issue number one.
Give me chance to get this one. Give me chance to get this one.
I was also seeking for audience to guide the court, my lord.
But let us see this one is a report. Let us get other issues. Yes, Pastor.
So the challenge and make it before you is that the court has provided us these gadgets to generate the record, which is ideally the authentic record.
Which one?
This record that we are seeing,
The report is on report they have doctored it on the required conditions.
every time we appear here, we are told to speak into the microphone.
Yes,
Because there is an official record.
the report I have captured as far as this
This record, the microphone has not captured the one.
I have reported that the required conditions were filed, and I have taken notice. One thing, I will later but how many people I said they are only this. But the no, I am taking you very important. So you see, to the required conditions, you want to ask them to treat it. But let me know if there is a consideration to vote fair. These ones. If they are only these ones, you tell me that these are the ones you want to look at.
But when will they be in this record?
I'm saying, are they the ones that now, so that I know these are the conditions you want to consider this?
There are some of the ones who want to consider.
Others, I'm asking others, these ones we shall come back.
It's difficult now to understand how we should proceed.
Do we have other considered apart from this that we are doing?
I don't have any questions that we first give.
Is it the only that we are going to part?
Well, there are others, but we want
Others
to
let
deal
me have
with
this.
this.
If you don't have them,
I don't we want to deal with those.
I want to be only with if you
If
later.
you are, oh my Lord, I think this is a bit of an uncomfortable situation. Because my Lord,
Are you saying you want only to deal with the issues filed on Friday in this later date?
my Lord,
Or there are other issues?
those are not our instructions. Our instructions are to first address you on those conditions.
This one, address me if there are other conditions which are not things. They are not clear. You know whether there are other issues to consider.
There are 6 more, because in total there were 7, my lord. And you
Can you
guided,
those which are not considered?
yes, there are 6 more. But you are guided that we first exhaust the first one.
No, let me have all.
Shall we again come back to the first, my lord? Because we need to.
kind of tell me if you have other issues.
There are 6 more.
So let me ask.
Why don't we first list the issues required, the particulars under 1, the facilities required?
instruction program, let me have other issues in the area which are outside these issues. We have other issues. Which are not in this. This is A to G. So if you have any other speeches,
My Lord, I don't know, I seek now, we seek to be guided now.
I'm going to let me have others.
We are just seeking guidance. That we first list them, then we come and substantiate all of them.
Okay. These ones are.
No, I am asking.
You have others.
You are asking, my Lord, that we list the seven,
I am saying
then we come and substantiate, because we have...
First give me others if you can. List them here. First list them here.
We list them, then we substantiate.
I am ready.
Okay, fine. Let's list them, then we substantiate it. Most obliged, my Lord.
And the leader referred to by my colleague. I align with the submission to the Minister Suit. We will not be in a position to interact as the question says. And the 11th. My Lord, we need time. My Lord, again, the land deputy appeared to misinterpret as rudeness. My Lord, it would be not good use of court facilities if we prepare for witness A and they bring witness B. So if they could kindly provide the order, those witnesses shall be deserted, we will be happy to make the necessary recommendation. And my Lord, again, to just reiterate what the court pronounced earlier, that prayer can be granted any time. We request for an orderly record of the preliminary matters and disposed of the applications. And that the court, as a custodian of the law, abides by the statutory command to dispose of the human rights enforcement application for the trial. Place his findings, in fact, on the trial. My Lord, that's good.
And now we proceed on the comment on the issue of agreed matters by both prosecution and the defense under section 67(2) of the DIA. The prosecution has very clear in their submission that according to them, they are ready to move their case if the defense so wishes, can generate the facts and the documents for the prosecution to agree on it. It is my considered opinion that parties are free to discuss and agree. Otherwise, this honorable court cannot force the parties to agree on the matters. I have therefore taken note that it's upon agreement of matters by parties that this honorable court will go ahead to prepare a memorandum, read it to the 12 persons, and then thereafter the said memorandum will be signed by the 12 persons and their lawyers. But in this case, preliminary hearings must also come to the end. We cannot keep parties insisting on agreeing on matters on the. So it is my considered view that upon listening to both the defense and prosecution, it is my view that I don't see any agreed matters under section 67(2). Hence, this court has no memorandum to sign. In conclusion, under section 67(3), also it goes ahead to talk about agreed facts or agreed documents. Still, the Neko court prepare memorandum. But in this case, and based on the submissions, I consider that there are no agreed facts. Therefore, having listened and made those comments that there are no agreed matters in this case, which, in my view, will lay this case, I have concluded that parties have not agreed on any matter. I will now proceed to choose 3 assessors under section 66 of DIA. The deputy registrar forwarded this honorable court 6 assessors for court to choose from. The 6 assessors are in court. The 5 assessors, the list of 5 assessors. I will go ahead and choose 3.
My Lord, before we proceed,
Just let me finish my ruling.
make an application for
Kindly let me finish my ruling.
I'm seeking to arrest the man, my Lord.
Kindly let me finish my ruling. I will now choose.
Before you appoint, my Lord, we have not submitted. We have not made any submission.
Kindly let me finish my ruling. So then I will now proceed to choose the following assessors. One is Musana John. Musana John has provided all his details.
My Lord, we have not addressed you on the qualifications. This is the reason I was seeking to arrest
I
you.
will go on section 83, section 84, section 88. And I'm just choosing so that you proceed. So Musana John is CP and President. Besigye Sarah. So Besigye Sarah Okero Richard. So these are the 3 assessors that I have chosen under section 66 to help this court during the trial and to give court opinion as far as the roles of assessors. I will now invite counsel for the located vote. After this, under section 68, with an assessor.
My Lord, before we go there,
Go there and then
no, before we go there, my Lord,
I'm saying we will go there and then you tell me we vote what you want. But now first we go to student. Then thereafter we go further.
no, we are still at a preliminary hearing, my Lord.
Council Power, you know, you will give court opportunity to guide you. So I think you will go there on section 68, up to 69. Just go to section 69. Challenge.
My Lord, we are still dealing with your ruling because certain aspects have not been addressed.
That one will address it later. Why are you denying?
We are not in a hurry, actually. It's court which is moving very fast, my Lord. My Lord, we are seeking for your ruling on the pending applications because we made the submissions in our application on pending application. We mentioned, my Lord, no, my Lord, we have this application 227, which is against General Muhoozi Kainerugaba, Colonel Peter Besigye, Lieutenant Colonel Ephraim Byaruhanga, and the Attorney General. My Lord, we submitted on Section 8 of the Human Rights Enforcement Act, which commands that the court shall stay proceedings. So, my Lord, you cannot proceed to appoint assessors when there is a command of Section 8 that proceedings must be stayed. No, this is what I'm saying, my Lord. But my Lord, I'm still submitting, my Lord. But you are taking me very far, my Lord, because there is Section 8 which commands the court to stay proceedings until the application is disposed of. And I'm addressing you on this application we have. Colonel Dr. Besigye, Obeid Lutale against General Muhoozi Kainerugaba. Yes, my Lord. But the moment you proceed to appoint the assessors, no, but my Lord, we are saying the proceedings must be stayed under Section 8. This is the submission we are making, and no, my Lord, we are saying before you proceed to appoint the assessors, the law commands that the proceedings be stayed. This is we are making a submission so that you make a ruling, and you have not made a ruling on this issue.
That one will come.
No, but my Lord, we submitted on it earlier, and you have not made a ruling. We ask you to stay the proceedings. No, my Lord, my Lord.
Can you sit down? Can you be professional?
I am professional, my Lord.
Sit down. Can you be professional and sit down? Respect this one and master.
I am respecting you, my Lord.
Can you sit down or you are not sitting down?
I will sit down. Thank you.
Then I should go.
But you have ordered me to sit down. I was still saying something. I was still making submissions. I was still addressing you, and you directed him to sit. No, my Lord, we are saying you cannot proceed to appoint. Yeah, and we are asking for a ruling.
No. So it's okay, wait for the submission. Let me hear. So if you are saying this, you say this.